New York City Foster Care Abuse Lawsuit, GMVA Rights for Survivors, Attorney Andrew M. Stengel. New York City's foster care system exists to protect its most vulnerable children. For hundreds of survivors, however, it became the site of severe sexual abuse. Abuse occurred in foster homes, group homes, and residential facilities overseen by the Administration for Children's Services, known as ACS, and its contracted private agencies. If you experience foster care abuse in New York City, a new legal provision may give you the right to pursue a civil lawsuit. The Gender Motivated Violence Act recently added Section 10-1104.1, a look back provision opening the door to civil accountability for survivors of gender motivated sexual abuse, including sexual abuse in foster care. Our attorneys at the law firm of Andrew M. Stengel, PC, represent survivors throughout New York and fight to hold every responsible party accountable. Who is legally responsible for foster care sexual abuse in New York? Multiple parties may share liability when foster care sexual abuse occurs in New York City. For example, individual foster parents or household members face direct personal liability for sexual abuse they commit. Beyond that, the City of New York and ACS bear institutional responsibility for failing to screen, place, and monitor foster families properly. Private foster care agencies, religious and secular nonprofits that manage placements and supervise families, carry their own independent liability under the GMVA. Furthermore, group home operators who fail to protect residents from abuse by staff or other residents also face full accountability. Working with an experienced New York sexual abuse lawyer is the most important step toward identifying every liable party in your case. How the GMVA lookback provision works for NYC foster care sexual abuse survivors. Under Section 10-1104.1 of the GMVA, survivors have an 18-month window to pursue civil lawsuits for gender motivated sexual abuse in New York. This window covers abuse that occurred before January 9, 2022, including historical New York City foster care sexual abuse that previously had no legal remedy. However, the window closes in July 2027, making early legal action critical for every survivor considering a lawsuit. Under this provision, survivors can sue both individual perpetrators and the institutions that enabled the abuse. Additionally, the provision covers sexual abuse motivated by the victim's gender, a standard that applies directly to sexual abuse inflicted on children in New York City foster care. Most importantly, this window is available regardless of when the sexual abuse occurred, provided it happened before the January 2022 cutoff date. Documented ACS failures that strengthen your New York City lawsuit. Patterns of ACS failure in New York City are well documented in internal reports, investigative journalism, and prior litigation. Caseworkers carry unmanageable caseloads that prevent adequate home visits and meaningful contact with children in care. ACS inconsistently applies background checks to foster parents and household members, leaving dangerous gaps in oversight. Additionally, ACS has a documented pattern of failing to investigate complaints from children in foster care. In many cases, the agency has systematically prioritized preserving placements over protecting children from ongoing harm. These documented patterns establish the institutional knowledge and negligence that underpin GMVA lawsuits against ACS and the city. Moreover, prior complaints to ACS, even those never acted upon, become powerful evidence once civil litigation compels their disclosure. Critical evidence and NY. See notice of claim deadlines. A CS and contracted agencies maintain extensive placement records, case notes, home visit logs, complaints, and investigation reports. These records can establish what ACS knew or should have known about dangerous conditions in a foster placement. Attorneys obtain this evidence through civil discovery and, in some cases, Freedom of Information law requests. However, notice of claim rules create an urgent procedural deadline for survivors pursuing lawsuits against the City of New York. A notice of claim is a legal prerequisite to commencing any lawsuit against the city. Failing to file one can jeopardize the entire case, regardless of the merits of your lawsuit. Therefore, consulting with an attorney well before July 2027 is essential for any survivor considering legal action. What civil litigation can mean for NYC sexual abuse survivors in New York City. Civil litigation can be an important part of healing for some New York City foster care sexual abuse survivors. A lawsuit provides a sense of agency, public acknowledgement, and financial resources for ongoing care. Some survivors find the process demanding and benefit from strong therapeutic support alongside legal representation. Beyond the legal work, a good attorney partners with the survivor's therapeutic team throughout the entire case, not just at the beginning. Still, many survivors find that pursuing accountability brings a sense of justice that supports long term healing. In New York, survivors pursuing GMVA lawsuits have the right to do so with confidentiality protections in place throughout the process. Protect your New York City foster care lawsuit before the GMVA window closes. If you or a loved one experience foster care sexual abuse anywhere in New York, do not wait to explore your legal options. The law firm of Andrew M. Stengel, PC, has extensive experience representing survivors in complex GMVA lawsuits against the city, ACS, and private agencies. Our attorneys know how to identify every responsible party, secure critical ACS records, and build a powerful case on your behalf. We represent clients throughout all of New York and pursue maximum compensation for every survivor we serve. All cases are handled on a contingency fee basis. You pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengelaw.com. For more information, please visit our website, stengelaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.